Welcome to the monthly Truck Stop webinar. These truck stops are provided the second Thursday of each month at 2 p.m. Eastern Standard Time. These webinars are presented as industry updates and for informational purposes only, and do not qualify for state CE credit. If you're seeking state CE credit, please email our office at prs@ibci.net. We do provide 12 hours of CE each year that also presented to the members of the foundation, and you get more information there. During this webinar, if you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar by email. If you experience any audio problems, please send us a note in the chat window or call 800-741-4084. We will attempt to correct the problems as soon as possible. Well, I got Dave Henry here. Seems like your partner, David, couldn't make it. Dave and I go back many years, a lot of things. Dave is an honorary member of the foundation based on the information he has provided to me and other people involved in this in the past. We're sitting in his office in Orlando, Florida, and Dave does a lot of work. Dave, tell me a little bit about yourself, and then we'll talk about what we're going to talk about this subject.
Thank you, Tommy. I am a litigator and a mediator, and about 10 years ago, I decided I liked being a purveyor of resolution as much as or more than being a litigator, what I call a purveyor of conflict. And so I became a mediator, and I have a broad mediation practice for civil disputes, including catastrophic personal injury, transportation, commercial torts, anything that your members might run into in a legal dispute, I will mediate upon the request of the attorneys, and that's what I do.
And Dave has some history in trucking. In fact, the first case we ever had with him was in trucking, and he also teaches the certified insurance counselors Ruke webinars that I also taught with David in those areas. So we're here at mediation, and my thought in this process, David, when we start, is that I understand the claims department have to be involved in mediation, but I'm not sure that retail agents who are part of this, or even the underwriters who work for insurance companies, understand this process. So I want to talk about both sides of that, because we know in most cases, and again, correct me if I'm wrong, but most court actions require a mediation somewhere during that process, so the judge doesn't have to make the rulings to see if the parties get together.
Right.
We've seen these things on TV, get back and settle it here. I actually had one judge one time told me in one case, David, or a mediator told me in one case, you can't trust this judge. You'll get a better job here.
Right.
That's what the judge is going to rule here.
Right.
So you might go through that, how once the suit's filed, then where does the mediation come in place?
Right. Well, actually, it can happen before suit, too.
Well, right. The parties want to agree to it.
Yeah, we have, so I'll say a significant part of my practice is pre-suit mediation. So people will come to me sometimes if they have a dispute. It could be an employment dispute. It could be a personal injury claim. But we sometimes mediate before suit. But like you say, most of the cases are going to mediate during the course and scope of litigation. Florida was the first state to mandate civil mediation, and that's where I practice. But the rules governing mediation are pretty much the same across the country. You're talking about a privileged, confidential proceeding, facilitated by a neutral, usually picked by the attorneys, or if the attorneys can't agree, then usually the judge will appoint a mediator. And you meet in a private conference, and there's usually some exchange of information to the mediator in advance. I usually get a position statement from each side to give me some background on what the case is about. We meet in a private room. A lot of times we'll have the lawyer, the client, the risk manager, in-house counsel, depends on who's involved in handling the claim. From the agent's perspective, it's important because your policyholders have a better chance of keeping their loss history down. They have a better chance of preserving their business relationships. They have an interest in getting their policyholders into mediation. I don't think retail agents, in particular, really think about that. They probably think, well, that's sort of in the claims unit, or that's a claims problem, and so I'm sort of hands off. I don't get paid to be in that discussion. I teach to insurance agents. I talk to them about E&O and handling their book of business. I would say the one key thought I would give to retail agents is you may not direct the process directly, but you can certainly encourage the process. You can push that to happen earlier. And the biggest problem I see, Tommy, frankly, is people come to me too late. This case has been pending for months and months and sometimes years, and I'm wondering why that case didn't get mediated earlier, and I will tell you one of the problems with the system is that the lawyers are hesitant to go into mediation until they have a lot of information. They want to take depositions. They want to know what the experts are going to say. They want to be able to tell the client, this is a good deal. When we're in the course and scope of negotiating, if you have a lot of information, you've been on the case for a long time, you can go to your client and say with some degree of confidence, hey, I think, paying $150 is about right on this file because I've taken all this depositions. I know all this information. We've seen all this. And so they have a high degree of confidence in their opinion later in the case. The problem with that is they've spent a lot of time and money to get to that level of certainty, to gather all that information. And a lot of times they would have been better off mediating that claim early with some uncertainty, with some variables, with some level of doubt. But the reality is a good lawyer and a good claims person can size up a case in the first 60, 90 days. Now, they may not know all the little nuances and pieces and parts, but you can get in the ballpark of what that case is worth pretty early, and you can mediate pretty early. And the role I would encourage retail agents to take is ask the question, when are we mediating this case, and why aren't we mediating it within the first 60, 90 days? And the good news is some of the carriers are actually developing and have implemented early mediation programs. I have a couple of carriers where they expect me to put the claim into mediation within the first 90 to 120 days. And if it's not in mediation within the first 90 to 120 days, I have to write a letter and a report explaining why that's not taking place and what are the impediments to mediating the case. But I will tell you there are a lot of carriers that are not that proactive in terms of getting the case into mediation. So retail agent can help drive that.
A couple things about this. We talk about carrier, obviously, every year. We talk about insurance carriers, not motor carriers.
Right.
I run into this all the time, David. Right. We're talking about this. But the retail agents involved in this. And even we had one a couple of weeks ago that got settled mediation where it was still under the reservation of rights. They hadn't figured out all the coverage questions, but there was pretty evidence that coverage would probably be there. So they went to mediation and they settled it without having the cost to get the deck action of coverage or not, because part of the figuring the company figured in is that by the time we get deck action, we're going to spend this much money we're going to pay anyway, so might as well pay it and get rid of it, and so everybody walked away happy.
Right.
And so the insurance agent can also explain to the insured about how this process works. Now, the thing I understand about mediation, David, none of these things are factual later. I mean, they're the facts that come out, but things come up later if you don't settle mediation. You haven't impaired your ability to fight the case as it goes down the side and find the judge of that. So this is just an early chance to save all that cost, all the cost of expert witnesses and this kind of stuff to try to get some dollars consideration out there. You don't realize, retail agents sometimes, and you can look at any claim that you have, and if you look at the loss cost of that claim, as well as what's the insurance paid, very often the cost to defend the case from expert witnesses to reconstruction of a crash, because those are the things we're talking about here, are auto crashes, are a lot of money. And if that can be settled to get out of it early enough, everybody's happy in that way. And that's a part that we have. Now, also understand that people who come here have to have the money with them, obviously. Do you encourage or would you welcome the insurance to show up and be involved in this part of it?
Oh, absolutely. In fact, in most jurisdictions, the insured, the party, the defendant, is required to come.
Okay.
You can't just bring the insurance carrier rep. You have to bring the actual client. Of course, some of your insureds are going to have SIRs and large deductibles, and so they're going to want some say in that process. Particularly if they're carrying $500,000 or $1 million SIR, they're going to want to know how their money's getting spent during the mediation, have some say about that. So yes, the insured needs to be there. The plaintiff's got to be there. The plaintiff's attorney's got to be there. The other thing I will tell folks, and I only know this because I've mediated so many times, people settle cases for a whole lot of reasons that don't have anything to do with the merits of the case. But you're not going to figure that out until you get into mediation. It happens all the time. You find out, okay, you have a plaintiff who's really, really injured, but they have a special needs kid. They can't afford to be in trial for 2 weeks in Jacksonville if they live in Orlando. They can't. Or they can't afford to, they got a sick mom or dad. All sorts of things like that impact a person's ability or willingness to go to trial because they have practical needs at home. So they will settle the case. Now, you're never going to learn that. You take their deposition. They're not going to admit you to that. Or they may have some other problem that just prohibits them from coming to trial. It's a real problem for them. Or or they have anxiety about the process, and so they want to settle the case. So mediation works for a lot of reasons that you wouldn't expect.
I've got a case right now with a case in Naples, Florida, where the lawyers, they found some lawyer, I guess on the internet, out of Orlando.
Right.
That lawyer's not going to go to Naples to fight this bicycle claim in Naples. But if you get mediation, they're going to get out early that instead of going through all that cost of having the lawyers themselves going to have to go down to Naples and fight those cases. Anyway, that's our introduction, David. So when David and I reached out to him because I've asked David a couple of times to be a part of an annual conference and do other things. And he did show up the first year, by the way, and I'm sitting in his office, and I've got his honorary membership sitting up on his bookcase in the back here. So I've done that in a number of lawyers, and I appreciate you recognizing that part of it, David. But he was here. We're going to have him in the future. But when we'll talk about truck stops, as some of you all know, it's not a struggle, but I try to bring things that are interesting to everybody every month here. And so, David, let's go ahead, and you got your outline. We set it up, so let's talk and go through the outline, if you don't mind.
All right. So I'd say in my first slide, mediation is a dark art, and that speaks to the issue of the fact that the mediation is a confidential privileged proceeding. Nobody's going to know what is spoken or said. I mean, the judge won't know, jury won't know. Any kind of concessions or discussions that occur during the mediation process in almost every jurisdiction are absolutely privileged. There are very few exceptions to the confidentiality rules. I mean, obviously, if you threaten somebody with bodily harm, or you batter somebody, or you engage in grossly unethical behavior as a lawyer, for example, there's exceptions for that. But 99% of what goes on in mediation is absolutely privileged, and the other 1% I've never seen come up in 25 years. So the good news is we can get into the mediation, we can have a candid conversation with the other side, and that confidentiality encourages a freedom of thinking and a freedom of talking, which is very useful because you can share things with the mediator that you wouldn't want to share with the judge or anybody else and help get the case resolved. The problem with mediation is that it doesn't have the sex appeal of trial. It's not something that's really revered by a lot of folks because it happens in a quiet, cloistered, confidential setting, and so people don't necessarily appreciate how powerful mediation is. I mean, we take a case, Tommy, involving, say, catastrophic personal injury, bad accident, multiple deaths potentially, and that case like that in the court system might take a couple of years to resolve, tens of thousands, hundreds of thousands of dollars in depositions and travel time and costs and motion practice and discovery fights and depositions and things. And we take that complicated dispute, we bring all the parties together in a room, in a conference room. We start at 9 o'clock in the morning, and by 6 o'clock in the evening, we have a deal. A lot of times we have a deal. By the way, I should tell you, the settlement rates of mediation are really, really good, depending on where jurisdiction you're in and what kind of mediator you have. The settlement rates range as high as 70 to 80%. So your chances of settling a case in most mediation settings is really high. But mediation is a hard thing to teach, and that's why I say it's a dark art, because it does occur in a cloistered, confidential setting. It's not like other things that we do in the law where you can read it or watch it or look at. For example, if you want to be good at opening statement and trial, or you want to learn how to cross-examine an expert, if you're a lawyer, you can watch somebody else do that. There's recordings, there's transcripts, there's videos. You can go to seminars and learn how to be good trial advocate. But they don't really have the equivalent for mediation advocacy. So mediation advocacy is not on par with trial advocacy because it's very hard to teach somebody to do something if you don't have a writing or a recording or a transcript or a video or something to show them. Lawyers are replicators, right? We just copy other people's behavior. That's how we learn. I mean, you learn as a junior lawyer from the senior lawyers, and so you sort of mimic their behavior. But because mediation doesn't have a recording, it doesn't have a transcript, there's no real feedback mechanism. Everybody goes into mediation, and either you come out with an impasse, meaning no deal.
So that's if you don't settle, you're no worse off. Other than you got more information. You start from zero as far as the court system, as far as the judge goes.
Right.
You just got more information. You know where the hard spots are. Right. You know what they're claiming, right, and things like that. So that's the big part of it. Let me ask you one question. We're worried about bad faith, David, and we're worried about the insurance industry where you got policy limits demands.
Right.
Now, if you get mediation earlier than that happens, that at least you know what the system is in that part. So that would be some of the protection against some of those policy limit demands Because now if you can get the mediation quickly, what happens, how can you force the plaintiff's attorney to go to mediation? It has to be agreed on both before the judge requires it?
If you're in suit, you're going to have to mediate in most jurisdictions.
Okay.
Now, some jurisdictions do make it voluntary, but a lot of jurisdictions make it mandatory. It just depends on what state that you're in. So if you're here, Florida, where I'm from, it's mandatory. Other states, the court will strongly encourage it, but won't make you. If you're in, excuse me, if you're in federal court, you're going to have to mediate that case. It's very rare you can avoid mediation. So the good news is it doesn't take a lot to get into mediation because the court's going to do that for you. And most of the time, even if it's a voluntary state, you can encourage the plaintiff's attorney to get into mediation because he or she has the same interest as the claims adjuster, which is they want to get paid and they want to get paid soon, and the claims adjuster wants to close the file. So the plaintiff's attorney and the claims adjuster have the same agenda because the plaintiff's attorney doesn't want to take the case to trial if he can avoid it because his effective hourly rate is much higher if he can settle the case for $1.5 million.
He gets a percentage of that part of it, and so he doesn't have all that time and expense spending that part.
He's going to get his 33% or his 40%, regardless of whether he spends he or she, right. He or she's going to get that recovery, regardless of whether they got 50 hours or 500 hours. So they're always motivated. I mean, a smart plaintiff's attorney is motivated to go to mediation. I would be shocked to find plaintiff's attorneys who don't want to mediate. That just doesn't make a whole lot of sense to me. And to your other point, which is even if you go to mediation, you don't settle the case, you invariably will learn something new about your case, about your parties, about the other side. Something you will learn about your case that could be very valuable. That maybe there's another party that you need to bring into the case. Maybe that you have a witness out there that needs to be talked to that hasn't been identified or something like that, or maybe there's some coverage issue that you hadn't thought of, or there's another policy that we hadn't thought about. It's like, oh, we need to get to the GL because it's not just an auto claim now; it's something else. So
just make a note. Dave was mediation. He called me about 2 years ago and said that attorney said there was coverage here. Is that true? Remember that call?
Yeah.
I said, David, unfortunately it is.
Yeah.
Because they came up with something that came up. David wants to know how the other auto works. Coverage works here. Remember that when you called me up, so you had to go back down and had more settlement that part. Right. But you didn't know about that until the mediation came up and brought that up. So those kind of things. All right, let's go ahead and read slides, David. Okay.
Right. So. So when I say mediation is a dark art, that's just the problem of teaching mediation is not easy. And so the lawyers in general are not as good at mediation as we'd like them to be because the system doesn't necessarily encourage that behavior early on. And so what happens is mediation tends to get delayed somewhat. And so your job as an agent or as a risk manager is to push for early mediation. And so that's important. All right. The other thing I want to talk about is what's happening in the plaintiff's room. It's really important to understand what's going on in the plaintiff's camp.
The way it goes, everybody meets together and everybody sets a case. Then they separate into different rooms, and the mediator runs between the rooms or moves between the rooms.
Correct.
And comes back and talks about certain points, some of which they say don't tell the other side, some of which you say tell the other side. But you talk about both cases and try to encourage where the bottom line. So these cases, you're looking at two things, aren't you, Dave? Three things. You look at the coverage, you look at the law, and you look at how they substantiate the damages. And this is why you as a mediator, you have to decide those three things. But so we'll talk about what's in the plaintiff's room now, because now they have the opening statement, now you're dealing with the plaintiff.
Right. So that's in we call private caucus. And so it's important to understand that plaintiffs, your typical personal injury plaintiff, or even your commercial plaintiff, if it's a commercial cargo claim or something like that, those plaintiffs typically are not litigation savvy, and they probably have never been to a mediation before. I mean, claims handlers have, risk managers have, and lawyers have, but the individual plaintiff probably has not. And I make this point all the time because people say, well, why does the mediation take so long? Why does it take them to get to 4:30 or 5 o'clock in the afternoon to make a decision? And there's a couple reasons for that. But I think one of the big things that gets overlooked is plaintiffs themselves do not know how to value their case. And they've never been taught how to do that. And when they first got injured and they first went to a lawyer, who did they think was going to decide their case? Well, they thought it was going to be a judge or a jury because every television show and every book and every movie that they've ever seen has somebody going to trial, right? They don't have a movie or a TV show about somebody going to a mediation at some lawyer's office. That's not a show. That's not very entertaining. So nobody thinks about mediation. They don't think about settling their case. They think about, well, who's gonna decide how much my injuries are worth? Then, and they think it's the judge. And then they come to mediation. The first thing the mediator says in the opening session is something like, well, today, Mr. Smith or Mr. Ruke, today is your day. Today you can decide whether you want to settle your case or whether you can continue. Today you have control over the outcome. Today you have control over how this claim gets resolved. You have to decide whether you want to settle this case. Well, when in the last 6 months of the case have they ever learned how to value their personal injury claim? Well, they don't really know how to do that. So obviously they're relying on their lawyer to a large extent. But the problem is...
So the mediator then helps them walk through how it's evaluated and how the court system...
Right. We talk about litigation. We talk about liability. We talk about causation. We talk about damages. We talk about comparative fault. Comparative fault. We talk about, well, your injuries have healed, so you don't have residual medicals. We talk about things like that. But the point I want to make to the audience here is that litigation process is disenfranchising, meaning it removes the plaintiff from his or her problem, because the litigation is all about, compliance with rules and procedures and deadlines and papers that have to get filed. And you're not really talking about the plaintiff and their injuries, because that conversation doesn't really take place until trial or until mediation. So what has happened is the plaintiff has sort of been marginalized during the litigation process and been sort of sitting there passively wondering, okay, what's going to happen with my case? And then we throw them into the mediation. It's like throwing in the deep end of the pool and say, okay, now you have to decide how much your case is worth. Well, what has gone on in the past 6 months or year of litigation to tell them that they have to make that decision and that they have to decide what their case is worth? And the answer is nothing. So they don't have any experience valuing their case. The litigation process doesn't teach them to make decisions, because the litigation process runs on a separate, schedule and axis that's independent of them. They're not controlling the litigation process. The rules of procedure control the litigation process. So they become disenfranchised from the actual accident and the original problem and the original injuries. And then in the mediation, what's happening during the mediation, the first 3 or 4 hours, is all that's happening in the first 3 or 4 hours is the plaintiff is getting comfortable with the idea of buying their own case, of valuing their case. It's sort of the analogy I use is like when you're going to go out and you're going to buy a brand new car. That's a pretty expensive undertaking. You don't walk on the lot at 9 o'clock in the morning and buy a car at 9:30 or 10 o'clock. Most people have to take several hours of looking at different models and thinking about it and getting their head around it and making sure it's the car they want. And they walk out of the dealership at 6 o'clock at night, if they're lucky. But most of my drive leave, it's 9 o'clock, it's dark out, and I'm the last one there. And I just hope I got the right color, because I can't see the color of the car when I'm driving off.
I remember you and I were going to look at a car where you go to the dealership here, and I had to have a CD player because the kids wanted me to have it in there.
Right.
But the support that they're making here, it's just like the car. The plaintiffs can say, am I comfortable with that settlement or not?
Right.
And it's not only a judge tell them or a jury tell them, they have that first choice to say, that seems like something I'm willing to do and get it now versus a year from now or 2 years from now.
But I'm telling you, it takes a long time for somebody to get their head and their heart in the idea of, I'm going to settle this case. Because this is a big deal for them. There's not very many times in a catastrophic personal injury case, or any personal injury case, there's not very many times in their life where they got to make that decision. God forbid, you wouldn't hope that they have more than one bad accident, right? So they're having to decide, is this fair value for my claim? And that's not going to be a decision that happens at 8 or 9 o'clock or 10 o'clock in the morning. It's going to happen late in the afternoon. Every mediator will tell you most mediations start at 4:30. That's when the serious talk.
They said they start they meet at 10, but about 4:30 is when we get down to that.
We get down to crunch time around 4:30. That doesn't mean time is wasted. Well, you're just wasting time. No, what's happening is you're like marinating the beef. You're getting plaintiff seasoned to take the deal, and that process cannot be rushed. It cannot be hurried. It's a very important psychological and transformative process that takes place during the course of mediation, which you in the defense camp are not going to see. But I'm telling you, it goes on the other side of the room. Is that they become amenable to the idea of settlement. So the point is, why do mediations take so long? Because they should. Because it's important.
And the same thing for plaintiffs. If the motor carrier feels, we sometimes, because you've heard them, guys, we paid too much. Insurance company shouldn't have paid that. They didn't do that. They also get an understanding about it there. They don't have the choice to accept that or not. I mean, they can accept what the plaintiffs had, but or the insurance carrier can accept that part of it. At least they get to understand the process of why sometimes we pay more than what they think is worth too. So
Right.
you get some understanding the other side.
Sometimes you learn new information that you hadn't appreciated before, or the case is actually worse than you think it is, or you get some new information that tweaks your valuation of the case, and so you go in with the expectations, okay, I'm going to pay $250,000 on this, and I get into it, and I go, well, I can't get it done for $250,000, but I can get it done for $300,000. I can't get the plaintiff to go below 300. We've worked very hard with the mediator to get them to drop below. They won't. So sometimes we stretch at the end of the day to pick up that extra $25,000, $50,000 to make the case go away, because at the end of the day,
it's going to save money in the long run.
It's going to save a lot of money. At the end of the day, we're probably better off biting the bullet, paying the money, and shutting the claim down.
I've always learned a closed claim is the best claim.
Right. I had a guy, a rep early in my career from Zurich. He was the head of claims or something like that, VP of claims. He said the only good file is a closed file.
Yeah.
The only good file. So they want to close the file. So, and because there's collateral consequences to litigation too. It's bad for your business. It can be disheartening to your employees. It can cause a lot of stress and anxiety for people. There's a lot of collateral damage associated with litigation that people don't necessarily appreciate unless you've been through it. And so shutting it down, I call it getting it done, D-U-N, done, is really kind of important. All right, so let's talk about what you can do to ramp up a mediation. And now this is something that if you're a retail agent, you're going to have less involvement in this, because the actual setting up the mediation we expect to happen between the defense counsel and the claims representative. But the point I always make is we need to have phone calls in advance of mediation to make sure, A, we got all the people that we need. Sometimes we have people who need to be at the mediation, but they're not actually named parties because for some reason the plaintiff didn't join them. But the defendant's saying, hey, I need contribution from the trailer. I need contribution from that franchisor. I need contribution from somebody else who the plaintiff has not elected to sue, but you want to invite them to the mediation. Or what we see, Tommy, very frequently is, because I do a lot of insurance agents and brokers, E&O, is oftentimes the agent will get invited to the mediation because there's a coverage problem that somebody thinks is the agent's fault. And so the agent will get invited to participate in the mediation, even though they're not a party, they haven't been sued, but they've sent a letter to the agent saying, hey, the limit's wrong, or you didn't have the right additional insured endorsement, or something like that. And then the insurance agent will be invited to the party, and a lot of times, not a lot, but sometimes the insurance agent with their E&O carrier will come and participate in the mediation of the underlying dispute because they can see what's coming around the tracks, which is a potential E&O claim. And if you can get in there early, you can sometimes buy yourself out of that problem for real cheap as compared to just sitting back and ignoring the problem and then have it blow up.
And then the judgment go against the insured, and then the insurance comes back
right.
and claims E&O against you.
Right. Now there's $1.5 million judgment, and now they're saying, well, we don't have any coverage for this. And so now you're staring down the bullet of $1.5 million, as opposed to if you'd gotten into an early mediation, you might have got it resolved for $100,000 or $200,000 contribution toward a global fund, because there may be other people contributing, right? Just because there's coverage problems doesn't mean the carrier's not going to pay something. Right. So if you're a carrier plus the trucking carrier plus the GL carrier, whatever kicks in, you can sometimes make it go away. But those phone calls and that discussion about who's going to be there is really important and needs to happen ahead of time. You need to sort of think about who needs to be in the room, and then have a conference call with the mediator in advance so the mediator gets educated and understands the interests of the parties, understands that there's coverage problems, understands just the facts of the case, but also sort of who the actors are and who the players are and that sort of thing. Those kind of conversations are really, really important. All right, selection of the mediator real quickly. When mediation first started back in the 1980s in most of the states, retired judges were very commonly chosen to serve as mediators because people thought, well, they have seen a lot of cases, and so they'll be wise and they'll be good people to have, because they bring a certain, gravitas to them and that sort of thing. And what has happened over the last 30 years is that people have come to realize that retired judges aren't necessarily the best mediators. In fact, they're some of the worst. And there's good ones, but the reason for that is because judges don't have to be creative deal makers. Judges sit on a bench and call balls and strikes. They go motion denied, motion granted, objection overruled, objection sustained. They grant motions and deny motions, and they conduct trials. They're not in the business of making creative deals with thorny coverage problems and multiple actors and dealing with SIRs. They don't have to deal with that. So what has happened in the mediation ranks is that you have now practicing lawyers who become mediators. I'm an example of that. And the practicing lawyers who understand the law, who are current on the law, who understand the parties, the interests and things, end up being pretty good mediators. So retired judges are not necessarily the answer, and in fact are not oftentimes the best choice. Can mediation be too early? Not really. Are most too late? Yes, for the reasons that I talked about. Don't let the judge set the timing of the mediation. You set the time of the mediation. You decide when's the best time to mediate this case, and I will tell you, most of the time you want to mediate it sooner rather than later because plaintiffs want to get paid, and plaintiffs equate speed with fairness. If you offer a plaintiff $100,000 30 days after the accident, or $100,000 a year after the accident, the $100,000 offered 30 days after the accident is a heck of a lot more valuable, fair, equitable, because they equate speed with fairness. The longer you're waiting to get paid, the more unjust it seems to the plaintiff, because the delay is treated by them as you don't care about me. It's disrespectful. I'm not important to you. Now, there's a whole lot of reasons why you may not be mediating in the first 30 days. But from the plaintiff's perspective, they don't understand what's going on the defense side of the table. All they know is I'm seriously injured and no one's paying attention to me and I'm not getting paid. So I always say get in there, mediate early. Even if you can't get it resolved, the fact that you mediated early will at least tell you, hey, what can I get the case for? I may not get it done for that number, but I know what I can get the case for. You've shown the plaintiff a willingness to get it done. It provides you with some defense against a later claim of bad faith because you were in active negotiations. So there's a whole lot of positives associated with an early mediation. And, all right, attendance issue is pretty important. Phone participation. One of the problems we run into in mediation is people want to appear by phone because the adjuster's in New York or the adjuster's in California or the claimant's here. It's really important that we get everybody physically present. In fact, some of the rules in some of the courts require that you be physically present. And if you want to appear by phone, you actually have to get a court order to do that. And that's how important physical participation is. So if you're involved in the case on the defense side and your adjuster says, I don't want to come in person, I want to appear by phone, understand that that's not the most optimal way of mediating because people who are on the phone are not actively engaged in the process in the same way that people are if they're physically present, because they may be on the phone for 20 minutes and then hang up and then go do something else while the mediator's in the other room, and they're not really focusing on the problem or focusing on the case. Their attention might be someplace else.
This typically mediated, we're talking about auto now. I realize you got cargo and you got other general liability also. Is it usually where the state the crash happens or the city that happens? I guess the two parties can agree to mediate off some away from that part of it.
Yeah, usually it's where the lawsuit is filed.
Okay.
So if the case is filed in Orange County, where I'm from, we're usually going to mediate here. We're going to pick our mediator from there. Now, sometimes it's more convenient to mediate the next county over or something like that. We'll do that, but that's just a matter of mutual agreement. The court doesn't really care where you mediate; they just want you to mediate. All right. The only thing I would also say is safety concerns. One of the things that good mediators will identify early on is, are there any safety concerns at the mediation? And I've had in rare cases, it doesn't happen very much in auto, but I've had cases where there was such animosity between the plaintiff and the defendant that you were a little bit concerned about their ability to control themselves and control their temper. Mostly that's like an employment context and things like that where you have wrong, sexual harassment or something like that.
You could bring road rage to
It
mediation.
could. So I would just say that if you have some concern over the ability of the parties to conduct themselves in a civil manner, then you need to alert the mediator to that, and the mediator will tell you how to best handle that situation so you don't have safety concerns. All right. Let's talk about multiple defendants. So in a case where there's multiple defendants, it's really important that you understand that whether this case gets resolved, it's not going to be solely upon you. You're not the only checkbook at the mediation. There might be somebody else expected to bring some money, and it's really important to get co-defendants to contribute to the settlement pot and to invite those co-defendants and make sure they're prepared. Make sure the other side is prepared, other co-defendants along with you are prepared to settle the case.
David, I understand that co-defendants would come from two ways. First off, the complaint that the plaintiffs put in more than typically 2 or 3 people they're trying to get money out of.
Right.
So they become a co-defendant. If we find another party, meaning the defense finds another party that should get involved in it, like the maintenance on a vehicle could be questioned, therefore you might want to bring the garage in on that part of it. Right. We have a chance to at least alert them at that point. They don't necessarily have to come to the mediation because they haven't been named to the suit yet. Right. But that would be something that they have an exposure for, and as you mentioned, the E&O carrier. Right. So the co-defendants would come two places, starting with the complaint, right. and what the plaintiff, who the plaintiff is alleging has negligence in the case, or right. money. And right. second, things that we might want to bring in to get more money involved in. It could be the shipper or the maintenance company or something like that.
Somebody who owes you potentially contribution
right.
or indemnity,
right.
depending on what jurisdiction you're in.
Right.
But it's called third-party joinder in most places. You're bringing in a third-party defendant or a fourth-party defendant, so that sort of thing. So the idea is that if you have multiple defendants, multiple payors potentially, whether they're named defendants or not, but multiple people contributing, you want to have a conference call between all these actors ahead of time to get on the same page and say, okay, what do we think this case is worth? What do we think, irrespective of who's going to pay how much do we think this case is worth? That's a very important phone call, because if you and I, let's say you're the garage and I'm the hauler, and we're in the case, and I'm thinking, okay, this case is worth about $1 million, $1.5 million global settlement, right? And you don't think it's worth that much. Well, we're going to have a real hard time when we get to mediation. If you think the case is only worth $500,000 and I think it's worth twice as much, and you'll say, well, I'm in for 10% or I'm in for 20%. Well, you're thinking 20% of $500,000. I'm thinking 20% of $1 million. So there's a huge difference there. So it's real important that I always think about like fractions, right? From math, like there's a denominator of the fraction and there's a numerator. We may disagree on the numerator, what your share is and what my share is. But if we don't agree on the denominator, like what's sort of the global value of the case, we're going to have a real hard time mediating this case. And that's what happens a lot in mediation is I might agree, okay, Tommy, I'm happy to take a 20% contribution from you, and you realize your side says that's a fair contribution. We're willing to do that to make this problem go away. But what we haven't done is we haven't had a discussion about what are we ultimately looking to pay this plaintiff. And if you don't get on the page about that early on, it's really hard to reconcile those views during the mediation process because there's a big delta there, right? So we can, if we're only a couple $100,000 apart in our valuation, that's one thing. But if we're $500,000 or $1 million apart in our valuation, we got a very difficult time trying to bridge the gap and get the case settled. So forecasting what our opening offer is going to look like and where we think we're going to be at the end of the day, and we need to have some sense of that before we get
always
to
come up with what's the walkaway number.
Right. Right. And it's a range. It's not a number. It's a range. It's a range. It's a range. You're going to say, okay, because there's going to be things that you're going to come up that might spook you, that might bother you, that might trouble you. There's always surprises. All right. So in a lot of cases, we have the underlying liability, but we also have a coverage problem, right? So there's a coverage attorney sometimes involved, whether there's a deck action or not. Sometimes there's a separate coverage attorney who's looking at this, doing a coverage investigation. You're sometimes going to want to invite that coverage person. That's one of the conversations you want to have. Is the coverage person coming to the mediation, right? Are they going to be there and participate? And if so, I want to know what that coverage person's going to say. I'll just tell you quickly. I've been in cases where I was the defense attorney. The coverage lawyer showed up, and he said things that were so caustic and nasty about the plaintiff. I didn't say it. He said it. Things about the plaintiff that made the plaintiff feel bad and was disrespected. He almost blew up the mediation, and so I want to know what the coverage lawyer is going to say before he or she gets in the room. That's an important conversation.
We tell agents, so for you to listen to understand, sometimes it's a question of coverage, but the suit's been filed, the insurance company will defend it under reservation of rights. And what we're talking about here is that this is still being defended under reservation of rights, meaning the coverage has not been completely resolved. That's the case that I just mentioned to you that got settled a couple of weeks ago under reservation of rights here because the coverage wasn't there, but it was everybody's benefit to go ahead and get it early before you go through the extensive coverage. This is what we're talking about here.
Right. So understanding, and if you have maybe you have more than one carrier involved, so are they all bringing their own claims people, or are they working collaboratively and they have a shared claims handling? You get those issues sort of resolved. That's kind of important. But understanding the role of coverage counsel, and look, having coverage counsel there can be to your advantage because if the plaintiff is saying, look, I'm suing XYZ trucking company, but there's a big reservation of rights out there and there's some serious coverage issues. And I'm the plaintiff, I'm worried about getting paid. Maybe they're not a big trucking company. Maybe they're a small mom and pop operation and I've got a significant claim, and there's a big coverage problem out there, I'm going to be a little bit worried about that if I'm a plaintiff's attorney, because this guy's only got 3 trucks, and if I tag him for $1 million or $2 million, he ain't going to be able to pay it. So the presence of a coverage counsel there can actually give you leverage in the other room with the plaintiff's attorney, because the mediator will walk in and say to the plaintiff's attorney, okay, you realize you have 2 lawsuits. You have this lawsuit, and if you win this lawsuit, you're going to have another lawsuit with the insurance company. And then the plaintiff is going, what? What do you mean? What do you mean? Meaning that you're sitting here in 2017, you're not going to get paid to 2020 because your first case isn't going to go to trial until 2018 or 2019, and the second coverage litigation is going to take another year or 2 after that. So you're going to be sitting here for a long time without getting paid. And that's a very powerful motivating factor for plaintiffs and plaintiffs' attorneys, because they don't want to be on the hook for 3 or 4 years of litigation. It's very daunting to them because they're not getting paid. So that's a little bit about coverage counsel. The other thing that we talk about, and this again is more for your claims people, but appellate risk. So time, collection, risk of appeal. I oftentimes tell plaintiffs' attorneys, I go, you know, if you tell me there's a $1 million policy, you tell me there's a really good chance you're going to be able to get north of $1 million at trial. So, and if you do that, what's going to happen? I tell the plaintiff's attorney, I go, well, if you actually tag them for $1.5 million, what are they going to do? They're probably going to appeal, because the carrier has an obligation in most states. The duty to defend includes a duty to appeal. You can't just strike a check and then throw your hands up and say, okay, insured, you pay I'll pay the first $1 million, you have to pay the other $500.
Yeah, really, because the judgment gives the insured. The only thing the insurance policy does is pay their portion of the judgment up to their limit. And so you have to defend until it's resolved. And you can't leave that gets back to that bad faith question.
Right.
You can't leave the insured hung out there for that extra until you have resolved all the possible options within the terms of the policy. So this is what some people don't understand. Most of the places, the insurance company cannot just post the policy limits and walk away.
Right.
The only time they can do that is when the judge allows them to do that, because there's not cooperation on the side. But most cases, they cannot walk away at that part of it.
Right. If they have a potential for appeal, there's some reason to appeal the verdict, then they have to explore if there's good grounds to do that. And even if it's not a strong case, they still may have to file the appeal, because you don't want to leave the insured exposed for $500,000 or $1 million of uninsured loss. So the duty to defend includes the duty to appeal. And so what I tell the plaintiffs and the defense camp is you have to factor in the time and hassle and potential delay associated with an appeal of the case. And that's very useful in the other room with the plaintiff's attorney, because he says, well, I don't want to take $750,000 because they got $1 million policy. I think I can get $1.5 million or $2 million verdict. I go, you don't want $1.5 million verdict, because if you get $1.5 million verdict, all you're going to do is get an appeal and a bunch of delay. The best verdict for you would be $999,000, because that verdict,
that check can be written today.
They can write that check, and the insurer doesn't have to worry about it. So if you get a home run, you don't want a home run, because a home run's going to get you an appeal, but you want a triple or a double. You don't want to. And once I start explaining that, and they go, you're just biting off another chunk of appellate litigation, they sort of get that. So turning the plaintiff's contemplated victory into defeat actually can be done, and that's really kind of an important concept. Okay. Pre-mediation statements. As a mediator, I want to get mediation statements from the other side. I want the lawyers to exchange mediation statements with each other, because they don't do that. And I'll tell you, I know this as a mediator, very often the lawyers will not send their mediation statement to the other side because they think it has to be confidential and privileged. But here's what happens in reality, Tommy, is they will send me a mediation statement. The defendant will send me a mediation statement, and he will tell me in a statement all the reasons why the defense case is good and the plaintiff's case is weak, and why they're overreaching, and why they think the plaintiff should settle the case. Well, why wouldn't you share that information with the plaintiff and the plaintiff's attorney, so he can go back to his client and say, well, here's all the things the defendant is saying, and here's all the things we have to be concerned about in this case. The plaintiff's attorney can use that letter that's written by the defense attorney with his own client to soften up his own client, because his client may have unrealistic expectations. Right. And if you give the plaintiff and the plaintiff's attorney your letter with all the reasons why there are problems with their case and things like that, then the plaintiff's attorney has something he can talk to his own client about. So when they come into mediation, their expectations have been tempered somewhat, have been lowered somewhat. They sort of know what's coming. But I'm telling you, as a matter of practice, the lawyers don't do that exchange. And you're really missing out on an opportunity to learn new information. So I always encourage them to to share those pre-mediation submittals.
And the pre-mediation statement, David, correct. You can add more later at mediation time, right?
Sure.
I mean, it's not limiting. It's just setting the thing out to set the tone of where we're going, to educate you as a mediator of what the subject matters are going to be and what you've got to later make a decision on, but let both sides know where they're coming from. So they're prepared to make their point or to defend the point.
Correct. And here's the other thing I keep telling the lawyers particularly. I say, listen, this is your only chance to write a letter directly to the plaintiff. Don't write it to me, the mediator. Write like you're writing to the injured plaintiff. Because as a lawyer, when are you going to have the opportunity to talk directly to the other lawyer, the other party, but without going through their lawyer? This is an opportunity to write a letter directly to dear Mr. and Mrs. Plaintiff or Mrs. Plaintiff. I represent XYZ Trucking Company through the liability carrier, and we're going to mediate your claim, and here's some things that you should know. And I would write those things as if the plaintiff was going to read them, because I want the plaintiff to read my letter. I don't care if the lawyer reads my letter. What I really want is the plaintiff to read my letter. And to set the tone is really important. Tone is so important in mediation, and we'll talk about that a little bit more, but tone's really important in sharing the other side. And if there's something that you need to keep confidential with the mediator, you can just add another paragraph to your letter that goes to the mediator only, and then they can do that. Okay. And then you have, like we were talking about earlier, you come to the mediation session, everybody's in a big conference room, the mediator sits at the head of the table, he or she will explain the mediation rules, confidentiality rules, and then there'll be the opening statements by both sides. The plaintiff will have an opportunity to talk to the defendants and the carriers about their plaintiff and introduce the plaintiff. Oftentimes it's the first time you've ever seen the plaintiff because you haven't eyeballed him before, you haven't looked at him. So that's kind of useful too. Do they make a good witness? Do they present well? Those sorts of things are really valuable. That's why, again, why phone participation isn't so good, although Skyping is okay, because if you Skype in, you can see the people. That's okay. That's a good compromise if you can Skype in. But opening session becomes really important from the defense side because they may have all sorts of funny thoughts or assumptions about you're going to be nasty or mean or you're going to be cold and indifferent because you're just a mean old insurance company, and insurance companies don't care about people. And so what I always try to do is humanize the characters in the process and talk a little bit about who's there. And so I'll introduce my adjuster and let him or her tell, where they grew up, where do they live, make them not just a, insurance company person, but a real individual, and then talk a little bit about where they came from, if they traveled today, and just introduce them as you would to anybody else you're introducing in a strange setting like that. And then in the opening, what I try to do if I'm a lawyer is I really try to talk directly to the plaintiff, or if I'm on the plaintiff's side, directly to the defense, and get them to understand that I'm a formidable adversary, but I'm a respectful adversary. And while I can defend the case vigorously, in the mediation, I don't pound the table and bark or threaten or tell them that their case is awful or that they're a liar. And I don't ever get into that in mediation, because what I want them to do, and I teach young lawyers this, is that you're not talking to a jury. You're not trying to convince the jury or judge that your side is better and that the other side is full of, they're liars, or they're malingerers, or they're faking their injury. Saying those kinds of things to the faker or the liar or the malingerer doesn't convince them of anything. It just makes them upset and angry. And if you want them to take...
So now they want more than the money. They want the pound of flesh to right their wrong.
Right. You're going to make them angry and upset in the first hour of the mediation. I then, as a mediator, have a very tough job managing their expectations if you've made them really, if you hack them off, if you get them really angry. And plaintiff's attorneys, and I know this to be true because I've had plaintiff's attorneys come to me when I'm the mediator in the private caucus, in the first private caucus, after the opening session. I've broken off, I'm going into the plaintiff's room. I'm sitting there with the plaintiff's attorney, and the plaintiff's attorney will pull me aside, away from his client, and he will come to me down the hallway and he'll say, David, I want you to thank the defense attorney for his respectful and polite opening statement, because it makes it so much easier for me to keep control over my client when the lawyer is respectful and kind to my client. And it's like, well, okay, that's a useful piece of information. So you're not trying to beat up on the other side, because if you're on the defense side, I keep telling you want them to take your check. At the end of the day, you want this guy to take your check, and you don't want it to be a very big check.
And you want it based just on facts, not emotion.
Right. You want them to make a rational decision about the benefits of taking your money today, and you don't do that, by making them angry. You get more flies with honey than you do with vinegar. and it's just a fact. So don't make them angry, and then don't talk to the plaintiff's attorney or the mediator. Talk to the plaintiff. And I tell my lawyer that they read the room. If they're not liking what you're saying, they're making funny faces, or they're distracted, or they're getting angry, stop talking. Stop talking. Read the room. Be very careful that you don't upset the actors early on in the process. That's pretty gosh darn important. No reason to make them angry, and make sure you read the room. All right, let's talk about some things we can do that happen during the mediation process, and what happens if we get stuck, right? So we're at the end of the day, and we're a couple $100,000 apart. Are there some things that we can do to get unstuck? There's a lot of things we can do, actually. First of all, understand that most lawyers and claimants want resolution. So there's a real drive toward the end of the day to get it done. And at the end of the day, everybody gets a little bit tired, a little bit exhausted, a little bit wore out, right? And so the analogy I like to use is, if you've ever been deep sea fishing and you get a big fish on the line, well, what happens early on when you first hook the fish? I mean, the fish is going crazy, and they're pulling the line out of the reel, just spinning out there. They may be 100 yards away from the boat. But over time, that fish is going to get tired, and then you're going to be able to crank the reel, and you're going to be able to get the fish back in. But when the fish is first on the line, you cannot crank the reel or the rod too hard, or you'll snap the line or pull the hook out. You got to let the fish run off the end of the boat. That's what they say in your deep sea fishing. And so the same thing sort of happens in mediation. What has happened over the last 4 or 5 hours is the fish has been running off the end of the boat. And you've been saying, well, they're a long way away from where I want to be. You're right, they are. But at the end of the day,
they just get closer.
The fish is going to lose some of the fight in the tail, and the fish is going to be not swimming so hard anymore, and you're going to be able to crank that fish in, hopefully, to get closer to the boat where you can snag them and bring them in the boat. That's what you're trying to do. So at the end of the day, understand that everybody gets a little tired. Everybody gets a bit worn down. If the mediator is doing a good job, the mediator has already got them to a number that's close to where you're going to be. Now, here's what happens in mediation a lot of times. Let's say you're in the defense camp and you've offered $500,000, all right? The plaintiff's at $1 million. You're saying to yourself, okay, well, gee, we're still $500,000 apart. That's a big gap. I don't want to reach that far. The reality is there's a private dialogue and there's a public dialogue. The public dialogue is the last offer and counter, which is $500,000 and $1 million. But internally, what has happened is in mediation is I already know that you're willing to go to $600,000 or $650,000 because you've told me that as a defendant. I already know in the plaintiff's camp that even though their demand is $1 million, I already know they're willing to take something in the eights. Yeah. They've already told me, because sometimes it slips out. Sometimes you can just tell from their body language. They say it's $1 million, but it's a soft $1 million. It's like, that's my demand or that's my last offer, but it's not really their last offer. They're just looking to, so there's an internal and an external dialogue. So in my mind as a mediator, I'm thinking, well, I know he's willing to pay $650,000, and I know they're willing to take $850,000. So you're really only $200,000 apart in reality, even though it looks like on paper you're $500,000 apart. So the mediator will have more information than you do about what the other side is going to do. But I'm not going to tell you, if you're the defendant, I'm not going to tell you that I'm thinking that they really would go to 8, because that's going to discourage you from moving. So I may hold that information back because they haven't authorized me to tell you that. They've only authorized me to convey an offer of $1 million, even though they may have privately told me we'll take $850,000, but they say, Dave, don't tell the defendant that. So what I'm saying is you're oftentimes a lot closer than you think at 4:30 in the afternoon.
Well, don't get mad the first hour or two.
Don't get mad. Don't get mad.
Come back. Just speed them up.
Understand, time is your friend. Time is your friend. And here's the other point is, whatever we spend in mediation is a fraction of the time we're going to spend in litigation.
Oh,
so if we spend, it's ridiculous. 1 day of depositions is 8 or 10 hours. So if we spend 8 or 10 hours mediating the case, that's just a sliver of the time that we would spend if we were litigating. So I don't understand.
Fun to develop the case post
mediation. Yeah, hundreds and hundreds of hours go into a fully litigated case. So if we spend 8 or 10 hours in mediation, that's a tiny drop in the bucket. So people who get upset and say, well, this is taking too long. Well, you want door number 2? Because door number 2 is the litigation process, and that's going to take weeks and months and years.
And you still have your check in 3 weeks, right. 3 years, I mean.
And you may not be done then because you may have post-trial motions and you may have appeals. The other thing we sometimes look out for, and you have to be mindful of this, again, it doesn't happen as much in auto as it does in some other kinds of cases, but there can be some non-economic considerations. I'll give you an example. We want to see a change in certain rules. We want to see a change in company policies. we want you to install a warning sign or a label, or we want some change being made to the way you operate or something, or we want you to start a
practice and all that kind of
some
stuff.
kind of employment practice or some sort of business operations or some kind of signage or some kind of warning. We want those pipes painted orange from now on so nobody gets burned. Whatever it is, sometimes there's something that's not really specific to the plaintiff, but they want to have happen because it makes them feel better. It happens a lot in personal injury cases involving minors. They will want a memorial established. They will want to have I've had cases where we, like at a hospital, we set up a little room that was in honor of the kid who died, or we created a wall board in memoriam of somebody, something like that. So look for here's one that's really simple. It comes up a lot and people don't realize, an apology. Yeah. Offering an apology in mediation is very, very useful, and it doesn't hurt you because you're in mediation. It can't be used against you in court. So you offer an apology, and you can do that without admitting liability. You can apologize and say, I'm sorry you're here. I'm sorry your family has suffered this loss. You don't have to admit liability. You just say, I'm sorry you're here. I acknowledge your pain. I know how difficult it is to be. I'm happy to be here. That kind of tone is very useful at the beginning. And so looking for non-economic things that you can offer, or things that aren't directly related to a cash settlement, but may have some value to the other side. You don't know what that would necessarily be, but looking for those things, like, does this matter? Right? What other things matter to you? That might be important. All right, so looking for the non-economic tokens or the things to offer somebody. Other things that you can do is you can propose, like we do brackets sometimes, like we'll say, well, I'll go to 400 if you go to 800. Rather than making a specific monetary offer, we propose a bracket, which is a way of sort of narrowing the gap.
So if the jury comes out to less than 400, they're going to get 400. Jury comes out to $1 million, they're going to sell 800.
You can do a bracket negotiation, or you can make it even more formal, which is what you're talking about, like a high-low.
Right.
You can do a high-low agreement. We can say, okay, and that's, you know when that's really good? That's really good in cases where there's a coverage problem, because the carrier wants to get a discount for the fact that there's a coverage problem here, but they don't really want to litigate their coverage issues if they can avoid it. And the plaintiff's attorney has some risk because, well, there is a coverage problem.
Yeah.
There's a collection problem. So sometimes you can do a high-low and say, okay, if the jury finds us to be more than 50% at fault, then we pay X. If the jury finds us to be less than 50%, we pay Y. Or we just cap the verdict and say, regardless of the verdict, the most we're going to pay is our policy limit. And the least you're going to get, even if we win, we'll still guarantee you $200,000 or something like that. So there's a safety net at the bottom for the plaintiff, which may be attractive to them. So those are some of the things that you can talk about in mediation. There's a lot of opportunity for creativity in the deal. It doesn't have to be just a straight cash settlement. Sometimes you can come up with these contingent issues, like if your expert's disqualified from testifying, we'll pay you, $150,000, and you agree to dismiss the case, or something like that. You can have those kind of discussions. So we're going to wrap it up here.
Yeah, you got. Is that the last slide?
I think that's the last slide. I would say the key. Couple key swing thoughts is mediate sooner rather than earlier. Sooner rather than later.
Again, can the regulation help facilitate that?
Yes. Just go to your defense lawyer and say, when can we get this thing? Let's get this thing into mediation. We don't need all the information to mediate. You just need the major chunks. So don't.
Earlier the better, because now you know what the issues are.
Right. If you have a wrongful death case, for example, I don't necessarily need to take the deposition of the mom and dad to find out. Well, of course they love their parents, and of course they're grief. Sometimes you don't need to take a deposition and know someone's in a lot of pain because their kid died or their husband died. Right. I don't need to take the wife's deposition for 6 months from now. I know what she's going to say. She loved her husband. He was a good father, and he was a good homemaker. That's what she's going to say. So why am I waiting 6 months to take her deposition? You don't need to do that. So mediate sooner rather than later. And I'm telling you, you're going to get pushback, but don't worry about that. Even if you don't settle the case, you're going to learn something new. You're going to learn, okay, what's really going on here? Something you didn't know that will set the table for a later discussion. So one of the things that happens, and this is real important, is you may not settle the case at mediation, but oftentimes a week or two later, everybody will have a chance to think about it, kind of stew on it a little bit, and everybody will move a little bit a week or two later. So sometimes I don't get the case done on Friday afternoon, but the next week I get a call from the plaintiff's attorney, and they go, well, we thought about it a little bit.
That offer selling the
well, or I was at 900. I'm willing to drop to about 850. The defense is at 700. Well, now we're not that far apart, so I'll call the other side and go, he's willing to make a little bit of a move. What do you want to do? And sometimes we get it done a week or 2 or 3 weeks later because everybody has made a good faith effort and everybody realizes how close they are. They just couldn't get it done today because maybe the senior claims person wasn't available, or it went past 5 o'clock and they need to get more. So those sorts of things can happen. So that's why I think mediation is such a powerful tool, because you have a lot of creativity, a lot of flexibility. You can get non-parties to participate, and you can make your own deal and shut down a complicated claim in a very short period of time.
Dave, that's wonderful. This is a thing, I've been in a lot of them, and I'm glad, and I think mutual agents don't know enough about how this stuff works. And I'm hoping that the hour we spent together with everybody here can help you. If you're the claims people, the value of mediation, and start thinking about a different tone. If you're a retail agent, you have no experience in this. If you're underwriters, know where this process is and what this process is, and have some expectations from your claim department to handle it this way. Dave, we always appreciate your help. We hope to see you around again somewhere else down the line. Do the next slide real quick here. Next month's truck stop webinar is scheduled for Thursday, August the 10th at 2 p.m. This webinar are open to Motor Carriers Insurance Education Foundation TRS members. It will be posted on our website if you want to have it play for somebody else. So all of our truck stops are available later for viewing. If you know someone who would be interested in membership, please contact us. David, with that said, we're out of here. Thank you, sir.
Thank you very much.